Actually floor, and you know what I'm talking about here on my channel right now.
Ibastias. What happened in court this week was one of those moments where, if you understand even a little bit of how civil litigation actually works, you can feel the ground shift under a case in real time. On Friday, a couple of filings quietly landed on the docket, and while they didn't come with flashing lights or dramatic press conferences, they may end up being the most devastating documents Blake Lively has faced since she decided to turn a messy film production into a full-scale legal war. What makes this moment so striking is not just that her claims are under serious threat, but the way in which her own responses appear to concede ground, abandon arguments, and place her in a procedural corner that is very difficult to escape. For nearly a year now, this case has lived loudly in the public sphere. There has been non-stop hubbub, endless online debate, fierce defense from devoted fans, and a persistent narrative that Blake Lively was bravely standing up to misconduct in Hollywood. But courts do not operate on vibes, fandom, or moral certainty. Courts operate on pleadings, jurisdiction, statutes, deadlines, and burdens of proof. And when you strip away the noise and look at the filings themselves, something becomes very clear. This case, at least as it currently exists, is deeply flawed in ways that cannot be fixed by rhetoric or reputation. On Friday, the Wayfarer parties filed papers that were, frankly, a masterclass in tone and substance. Their attorneys managed to do what good litigators often do when they are confident in their position. They combined sharp legal analysis with a controlled sense of wit, the occasional quip, and a confidence that only comes from believing the law and the record are on your side. While Blake Lively's supporters scrambled to defend pleadings that are increasingly indefensible, Wayfarer's counsel calmly laid out why this case may never see a jury at all. At the center of this moment are two procedural off-ramps available to the judge. Either one could end the case without any ruling on whether Blake Lively was sexually harassed. That fact alone is important, because it explains why this is such a dangerous moment for her. Judges are human, but they are also pragmatic. If a judge can dispose of a case cleanly on jurisdictional or procedural grounds, without making credibility determinations or wading into emotionally charged allegations, that is often the path of least resistance. The first off-ramp is the motion for judgment on the pleadings. This is not about evidence. This is not about discovery. This is about whether, assuming everything in the complaint is true, the law even allows the case to proceed. The second off-ramp is summary judgment, which looks at whether any genuine disputes of material fact exist that would require a trial. What makes Blake Lively's situation uniquely precarious is that both off-ramps are in play at the same time, and her own litigation strategy has arguably weakened her position on both. When Blake responded to the motion for judgment on the pleadings, she did something unusual and risky. Rather than directly engaging with the arguments raised by Wayfarer, she effectively said, "Just convert this to summary judgment." That might sound like a minor procedural request, but it is anything but. The judge had already addressed this issue earlier. He explicitly told Blake that the motion for judgment on the pleadings was not untimely, that he would consider it, and that he would review it at the same time as the summary judgment motion. He did not say he would merge them. He did not say he would conform one into the other. He said he would review both. That distinction matters. Wayfarer's motion for judgment on the pleadings relies exclusively on the pleadings and documents already filed with the court. They did not introduce extrinsic evidence from discovery. They did not attempt to sneak factual disputes into a procedural motion. They played it straight. Blake, on the other hand, largely declined to meet those arguments head-on. Instead, she asked the judge to effectively ignore them and focus on summary judgment instead. This creates a serious risk. When a party fails to respond to arguments raised in a motion, courts can treat those arguments as conceded. That does not mean the judge must rule against her, but it absolutely gives him the option to do so. And when you read Wayfarer's reply, they make it very clear that they believe Blake has abandoned critical elements of her case. One of the most significant of those elements is the requirement that she plead an adverse employment action. Under both California's Fair Employment and Housing Act and federal law, retaliation claims require more than just discomfort, criticism, or interpersonal conflict. There must be a tangible, negative change in the terms or conditions of employment. Wayfarer argues that Blake did not even attempt to articulate such an adverse action in her response, and therefore has waived the issue entirely. If the judge agrees, the retaliation claims alone could be dismissed without ever touching the harassment allegations. But that is not the only problem. Another fatal issue lies in the extraterritorial application of California law. California's FEHA is not a global statute. It does not automatically apply to conduct that occurs outside the state, involving non-California residents, with no meaningful nexus to California. The law is clear on this point. To apply FEHA extraterritorially, there must be a substantial connection between the alleged conduct and the state of California. Wayfarer argues that Blake has utterly failed to establish that nexus. Not weakened it. Not partially shown it. Failed it entirely. If the judge agrees, that alone is sufficient to dismiss the FEHA claims outright. Again, no credibility findings required. No statements about who said what on set. Just a clean jurisdictional ruling. There is also the issue of administrative exhaustion, which is where things begin to look even worse for Blake. When she initially filed her lawsuit, she did not file the required CRD complaint in the name of It Ends With Us Movie LLC. She later amended the complaint after receiving a right to sue notice, but she admits that no new right to sue letter was issued because the administrative case had already been closed. That means, as Wayfarer points out, she never actually obtained a right to sue for the entity she later named. Courts take this seriously. Failure to exhaust administrative remedies is not a technicality. It is a gatekeeping requirement. Then there is the EOC dismissal. For the first time, Blake revealed that she received an EOC dismissal in January 2025. The timing alone raises eyebrows. The EOC rarely dismisses cases within 4 weeks unless there is a clear procedural defect. They do not typically rush to judgment on the merits. They dismiss when a claim is untimely, jurisdictionally barred, or otherwise defective. Here, the timeline is devastating. The alleged incidents occurred in May 2023. Blake did not file with the EOC until December 2024, well beyond the 300-day deadline. That makes the claim time-barred. When the dismissal document eventually becomes public, it is highly likely to state exactly that: lack of jurisdiction due to untimeliness. While EOC findings are not binding on courts, they are not meaningless either, especially when they confirm statutory deadlines were missed. All of this feeds directly into the judge's options. He can dismiss based on failure to exhaust. He can dismiss based on lack of extraterritorial application. He can dismiss based on failure to plead an adverse employment action. Or he can move into summary judgment and decide the case on employment status alone. That brings us to what may ultimately be the most powerful argument of all. Blake Lively was not an employee. Wayfarer contends she was an independent contractor operating through her loan-out company. This is not a fringe argument. It is supported by contracts, conduct, and the structure of the production itself. And if the judge agrees, most of her claims collapse instantly. Federal discrimination law does not protect independent contractors in the same way it protects employees. California has exceptions, but they are narrow and fact-specific. What makes this particularly striking is that Blake's own conduct undermines her position. She exercised extraordinary control over the production. She negotiated her terms aggressively. She demanded changes to schedules, locations, and creative decisions. She worked on other films simultaneously. She sought and ultimately obtained a PGA credit that signals primary producer authority. All of these facts cut against the idea that she was a subordinate employee subject to unilateral control. And yet, in her summary judgment response, she attempts to frame herself as just that, an employee who suffered retaliation. Wayfarer dismantles this framing with precision, pointing out that her compensation did not decrease, her role was not diminished, and her opportunities expanded rather than contracted. She received endorsements, references, and professional accolades. There is simply no evidence that any material aspect of her working relationship worsened. What emerges from this is a picture not of a woman crushed by retaliation, but of a powerful actor-producer who became dissatisfied with how events unfolded and escalated ordinary production conflicts into litigation. That may play well online, plays very differently in court. By the end of Wayfarer's filings, the message is unmistakable. This case can be dismissed in multiple ways, none of which require the judge to declare Blake a liar or rule on the truth of the harassment allegations. That is what makes this moment so dangerous for her. When a defendant hands a judge several clean exits, judges often take one. What makes the situation even more precarious for Blake Lively is not just the strength of the legal arguments lined up against her, but the way her own litigation strategy seems to quietly acknowledge that she cannot win every battle at once. When a plaintiff has to choose which arguments to defend and which ones to effectively abandon, that alone tells you how boxed in they are. And that is exactly what appears to have happened here. Faced with a judgment on the pleadings that directly attacked the legal sufficiency of her claims, Blake's team made the calculated decision to largely ignore those arguments and push the court toward summary judgment instead. That is not a sign of confidence. That is a sign of triage. Courts notice when parties do this. Judges notice when a response fails to engage with specific legal points. Judges notice when a litigant tries to reframe the battlefield rather than fight where the law demands the fight happen. And judges absolutely notice when a plaintiff fails to defend core elements of their own claims, such as damages, adverse employment action, or jurisdiction. Silence in litigation is rarely neutral. More often than not, it is interpreted as concession. One of the most damning aspects of Wayfarer's reply is how thoroughly they point out that Blake failed to meaningfully defend her damages claims at all. Damages are not an afterthought in civil litigation. They are a required element. You cannot simply allege harm in the abstract and expect a case to survive. You must tie specific, legally cognizable damages to the conduct alleged and to the proper plaintiff. What Wayfarer argues, convincingly, is that Blake has done none of that. Instead, she appears to conflate personal reputational harm with speculative business losses allegedly suffered by separate corporate entities that are not even parties to the lawsuit. Courts are very strict about standing. A plaintiff cannot recover damages on behalf of companies that are not before the court, particularly when those companies are legally distinct entities. That is not a technicality. That is black-letter law. And when Wayfarer points out that Blake failed to oppose their damages arguments at all, they are essentially telling the judge that this issue, too, can be resolved without controversy. The contrast between Blake's narrative framing and the legal reality becomes even sharper when you examine how her sexual harassment claims have evolved over time. In her response to summary judgment, she appears to concede, either explicitly or implicitly, that much of what she previously alleged does not rise to the level of actionable sexual harassment. She narrows her focus to just two incidents: the birth video and Jamie Heath entering her trailer after knocking. That narrowing is critical because it undermines the broader hostile work environment theory she originally advanced. Wayfarer seizes on this immediately. They argue that Blake herself seems to recognize that Justin Baldoni's conduct does not support her claims. Instead, she pivots toward Heath, attempting to recast him as the central figure in the alleged harassment. But even there, the facts, as described in the record, fail to support her theory. The trailer incident involved a knock, an entry, and an immediate acknowledgement that the situation was awkward but not malicious. Blake herself reportedly said she was not accusing him of trying to cop a look. That kind of contemporaneous statement is devastating to a later harassment claim. The birth video incident fares no better. The video was shown in the context of producing a film with a childbirth scene. It was shown not only to Blake, but to others involved in the production, including Baldoni, without offense. There is no evidence that it was sexual in nature, targeted, or intended to humiliate. Courts do not evaluate harassment claims in a vacuum. They look at context, frequency, severity, and whether the conduct altered the conditions of employment. On this record, Wayfarer argues none of those elements are met. What Wayfarer does particularly well is zoom out and remind the court of something that often gets lost in high-profile cases. Film productions are intense environments. People yell, tempers flare, creative disagreements happen, awkward conversations occur. Not every uncomfortable interaction is harassment, and not every conflict is discriminatory. If courts treated every raised voice or clumsy conversation as actionable misconduct, the entertainment industry would grind to a halt under the weight of litigation. This is why the employment status issue looms so large. If Blake is deemed an independent contractor, the vast majority of her claims vanish instantly. And the record supporting that conclusion is extensive. She worked through her own loan-out company. She negotiated her own rates. She maintained the freedom to work on other projects. She exercised substantial creative and logistical control. She even altered the production schedule to accommodate other work. These are not hallmarks of an employee. They are hallmarks of a sophisticated business entity engaging in a business-to-business transaction. California's business-to-business exception further complicates her position. Under the labor code, when two businesses contract with each other under certain conditions, the individual performing the work is barred from claiming employee status. Wayfarer walks through each statutory factor and shows how Blake's situation satisfies them all. The contract was in writing. The payment terms were specified. Her company was registered and taxed as a business. She provided services directly to the production, not to consumers. She advertised herself as available for other work. She negotiated hours, locations, and terms. The conclusion they draw is blunt but effective. If Blake Lively is not an independent contractor under these facts, then the concept of an independent contractor has no meaning. This argument does more than just threaten her discrimination claims. It undercuts her entire narrative of powerlessness. You cannot simultaneously argue that you exercised near-total control over a production, demanded a PGA credit signifying primary producer authority, and were nevertheless a vulnerable employee subjected to unilateral employer power. Those positions are fundamentally inconsistent. Wayfarer does not need to accuse her of bad faith to make that point. The inconsistency speaks for itself. Another quietly devastating aspect of the filings is the discussion of retaliation and PR. Blake alleges a smear campaign, yet fails to identify a single false statement made by any defendant. Posting videos of her own prior statements is not defamation. Highlighting already public criticisms is not fabrication. And hiring a PR firm in anticipation of potential litigation is not retaliation. Companies are allowed to prepare defenses. They are allowed to manage public perception, especially when internal conflict threatens to spill into the press. Wayfarer also points out that the PR firm was not hired because of Blake's protected activity, but because of escalating disputes over control of the film. That distinction matters legally. Retaliation requires causation. Without evidence that protected activity motivated the alleged adverse action, the claim fails. And again, Blake's failure to defend this element meaningfully leaves the court with little to work with. Perhaps the most telling detail of all is the abandonment of contract claims. Blake simply does not defend them. Wayfarer asks for their dismissal, and there is no substantive opposition. Courts do not rescue claims that plaintiffs themselves have left undefended. When a litigant walks away from portions of their case, judges generally let them go. When you put all of this together, a clear picture emerges. This is not a case teetering on the edge because of one weak argument. It is a case riddled with vulnerabilities at every level. Jurisdiction, administrative exhaustion, employment status, adverse action, damages, and evidentiary sufficiency. The judge does not need to weigh credibility. He does not need to decide who is telling the truth about conversations on set. He does not need to label anyone a liar. He can simply apply the law. And that is why this moment is so dangerous for Blake Lively. She brought this case. She chose this forum. She framed these claims. And now, faced with multiple procedural exits, the court may take one. If that happens, it will not be because the judge disbelieved her story. It will be because the law does not support it. The irony is that by narrowing her claims, abandoning arguments, and reframing her strategy midstream, Blake may have unintentionally strengthened Wayfarer's position. Each concession makes dismissal easier. Each silence speaks louder. And each attempt to avoid direct engagement with legal defects increases the likelihood that the court will resolve them against her. In the end, this case may stand as a cautionary tale. Litigation is not a press release. It is not a social media campaign. It is not won by volume or conviction. It is won by meeting legal standards on time with evidence and coherent theory. Right now, the filings suggest that Blake Lively's case fails to do that in multiple independent ways.